Hello everyone, welcome to KCAB International Friends webinar series. Let me introduce myself. I'm Sangyub, a case counsel of KCAB International. It is a great pleasure to meet you in this webinar. Today is the 11th episode of this series, which has begun since last year, June. Title of today's webinar is Resolving Commercial Disputes in Southeast Asia, Recent Trends and Issues. And our friend who is co-hosting this time is from Herbert Smith Freehills, also simply known as HSF. As we all know, the HSF is one of the international top-tier law firms, and especially after opening its Seoul office in 2013, it has been advising on a large number of overseas investments and commercial disputes involving many Korean companies as well. On behalf of KCAB International, I would like to appreciate joining this time and be with us to provide your professional perspective and information on this topic. As we all understand, it is obvious that the influence of Asian countries and related markets is fast growing in global economy, and it results in the increasing of cross-border transactions and related disputes. In this regard, as an effective way for resolving the disputes, the importance of international arbitration is also being emphasized much as well. So we will explore recent issues and trends faced in resolving disputes across Southeast Asia and several countries such as Vietnam, Indonesia, and Singapore, more specifically. Throughout the webinar, please feel free to make use of question chat box and type in your questions. Then the speakers will endeavor to answer them after panel discussion in Q&A session. So before we start the webinar, let me call on Hyun Lim, the Secretary General of KCAB International, to give her welcome remarks. Sue, the floor is yours.
Thank you. Thank you very much for that kind introduction. Welcome everyone. Thank you for joining us today for the webinar called Resolving Commercial Disputes in Southeast Asia, Recent Trends and Issues. As Sean just mentioned, this is part of our KCAB and Friends webinar series, which has been one of KCAB's knowledge sharing initiatives since the beginning of the COVID pandemic. KCAB International is pleased to be co-hosting this webinar with our dear friends and colleagues at Herbert Smith Freehills, who will share their experience and expertise in resolving commercial disputes in Southeast Asia. KCAB has been and still is the Seoul Arbitration Center in Korea. And for the last 50 and more years, KCAB has provided a neutral and reliable dispute resolution platform for a countless number of parties of various and diverse nationalities. Historically, the majority of users of KCAB have been Korean companies who have referred their international disputes to KCAB, which they encountered during their overseas businesses. As the Korean economy grew and Korean companies have become more globalized, there has been a sure and steady increase of KCAB cases involving many and diverse jurisdictions. And simultaneously, KCAB's reach, and together with this, the range of acceptance of KCAB by international users have been expanding in the recent years. Southeast Asia remains a particularly relevant region for KCAB International, as Southeast Asia is a stage where many Korean companies have their investment and business presence. Trade and investment volumes between Korea and the three jurisdictions that will be discussed in this webinar, namely Vietnam, Indonesia, and Singapore, have visibly increased over the years. The recent KCAB data on the nationality of users also is evident of this. The data shows that approximately 46% of the non-Korean parties using KCAB were from Asia Pacific region. And within that group, parties with nationalities of Vietnam and Singapore added up to about a quarter of that number. Also in the past years, Indonesian parties also have featured prominently in the KCAB nationality rankings. As fast-growing economies, Vietnam and Indonesia are two jurisdictions that are considered to represent great opportunities for Korean companies, and hence it has been the stage for many Korean companies to invest and to do business. Singapore represents one of the leading industrialized and developed countries, jurisdictions in Asia, and always serve as an example to surrounding jurisdictions as to the advancement of law. So with the relevance of these three jurisdictions, it is necessary for Korean companies to keep pace with the developing and evolving legal infrastructures and the legal trends that are happening out there in these jurisdictions. And it's necessary to have reliable information and advice from experts on the developments. For this, we're immensely grateful for our friends in Herbert Smith and Free Hills, particularly the speakers who will speak on their experience on the issues. And without further ado, let me turn the floor back to Sean, who will introduce us to the speakers. Thank you very much.
Thank you, Sue, for sharing very insightful remarks and information. And then we are ready to start our webinar. And let me introduce another leading MC for the main contents, Mr. Mike McClure, head of Robert Smith Free Hills Seoul office. Then I will pass over my mic to Mike.
Thank you very much, Sean and Sue. It's our great pleasure at Herbert Smith Free Hills to be putting on this webinar today with our friends at KCAB, and we hope that everyone listening will find it instructive. If we could move to the next slide, please, I'll briefly introduce everyone who is speaking today. My name is Mike McClure. I'm the head of Herbert Smith Free Hills here in Seoul. I'm also an international arbitration lawyer, and I've been here now for over 5 years, and in that time I've helped a number of different Korean contractors and other Korean parties involved in arbitrations and other disputes in Southeast Asia, working with my colleagues and working very closely with Gitta and Dan, who you'll hear from today. If I just introduce briefly the other two speakers, who are two eminent experts in this region. Gitta Satryani is a partner in our international arbitration practice. She splits her time equally between Jakarta and Singapore, and spends the majority of her practice helping both Indonesian parties and foreign parties in Indonesia in a range of disputes matters, particularly international arbitration. Dan is also an international arbitration specialist. He's a counsel in our team. He's based in Singapore, but we very much use Singapore as our hub for the entire Southeast Asia region, and from there assist clients in all the different jurisdictions in Southeast Asia, both in disputes and in particularly international arbitration, which is the specialism of the three of us here today, but also we've helped a number of clients in front-end transactions. And obviously I do a lot of work for Korean clients being based here, but both Gitta and Dan have worked with me, and indeed Gitta is currently working with me on matters for Korean clients in Southeast Asian jurisdictions. If we can move to the next slide, please. We have, this is just a summary of what we're going to talk about today. So I'll deal with the first 2 points very quickly, just to introduce our platform and to present to you an overview of some of the recent trends and issues in Southeast Asia. And then I'll hand over to Dan and Gitta, who will do a deep dive in relation to the specific jurisdictions. The slide we have up here just shows you very briefly our platform, and if you'll forgive me, it's a short plug for our firm and our experience in the region. We are one of the largest and leading international law firms in the Southeast Asia region, not just in terms of number of lawyers, but those numbers are significant. But in the depth of experience that we have, we've been practicing in many of the major Southeast Asian jurisdictions, in Singapore, in Thailand, in Indonesia for many years. We're also incredibly experienced in both Vietnam and the Philippines, and we've been doing deals and transactions there for over 20 years, primarily staffed by lawyers in our Singapore office who have been able to fly in and fly out. And so we have, as you can see on the slide, over 20 years experience in both of these jurisdictions, as well as many of the other jurisdictions that are relevant in Southeast Asia. We've done work in Cambodia and Laos, and we've got a strong alliance with a local law firm in Myanmar, and at times even have had our own people seconded into law firms in Myanmar. I raise this not just to highlight the depth of our experience, but to emphasize why it's important. And the reason it's important is that we refer to Southeast Asia as one region, particularly those of us in Korea and elsewhere who are not based in Southeast Asia. But actually, it's a very very complex and very disparate region. There are 10 countries in a relatively small space that make up the 10 ASEAN nations, but there is huge diversity between them in terms of language, in terms of culture, in terms of politics. You've got full democracies there, you've got communist systems there, you've got royal family ruling in some states. The legal systems are very different. Some are common law systems, some are civil law systems, some are hybrid legal systems. The languages are very different. In Malaysia, there are elements of Islamic law as well. And so there really is a lot of things to be considered when you are doing business in this region, and specifically when you're doing business in certain countries in this region. And so I would hope that a firm like ours would be very well placed to help you when you are working all over the region, and we can help you to navigate through some of the eccentricities of culture or language or even legislation in particular jurisdictions. If we can move to the next slide, please. I thought I'd just very quickly highlight some of the recent trends in relation to foreign direct investment in Southeast Asia. As Sue said in her opening remarks, Southeast Asia, and in particular the countries that we're going to focus on, Singapore, Indonesia, and Vietnam, are huge recipients of FDI from Korea. I think in Vietnam, Korea is the #1 foreign direct investor, and the volumes of foreign direct investment from Korea into the other states is incredibly significant too. There are obviously things to be aware of, and at a sort of very, very high level, there are usually in most jurisdictions certain restrictions or conditions on foreign investments in certain sectors that may be restricted or even closed to foreign investment. There are normally issues in many of these jurisdictions with government authorities and approvals that you need. And we've certainly had issues with clients in the past, including Korean clients, who have found out after their investment or even after they've started their project that they didn't necessarily have all the approvals that they've needed. And certainly Gitta will be able to tell you some war stories about where sometimes policies aren't even written down. There's also the final point there on the slide, on the whole, a massive infrastructure gap in Southeast Asia. They are in great need of the whole range of infrastructure, roads, airports, and a number of sort of development facilities as well. And that, of course, creates opportunities for countries and clients who are specialized in those areas. And that, of course, includes in particular Korean companies, and in particular, there's a significant amount of Korean EPC work going on in these jurisdictions on those sort of marquee investment projects, as I'm sure you're all aware. If we could go to the next slide, please. We've just flagged here some of the very recent trends in the region that we have seen as a result of COVID. and in particular trends that we think will be of relevance to Korean companies looking to do business in the region. There has been a huge growth in the digital economy in Southeast Asia. That, of course, was present pre-COVID, but has accelerated there. There is a significant population, relatively young population, not as plugged into technology perhaps as other parts of the world, but very, very interested in it. And many sort of electronic and digital platforms are seeing exponential growth in the region. And you can see that with some of the deals and issues we've highlighted there on the slide. And then in the second box there, we've got some of the investment trends and other key sectors. And we've seen that Southeast Asia aims to attract a lot of labor-intensive manufacturing. Vietnam in particular is a bright spot for that. There has been a boost in the number of IPOs in Indonesia. And there we're seeing growth in a number of other sectors: the financial services sector, the education sector, the healthcare sector, pharmaceutical sector, infrastructure and renewable energy sector. And all areas, particularly the latter three, pharmaceuticals, infrastructure and energy, where we're seeing a lot of interest and investment from Korean clients. Next slide, please, which is the final slide from me. Despite all these opportunities, as I'm sure everyone on this call will know, they're still not the easiest places to do business. They both, particularly Indonesia and Vietnam, score very highly on a whole sort of different global corruption rankings, and also, in addition to a potential corruption threat, just generally doing business is difficult, with requirements for things to be stamped, to be notarized, to be in local language, to be original copies rather than email copies. They're generally difficult places to do business, and therefore it's very important to make sure you've got advisors on the ground who can help you with that and can help you to navigate through that. And as I said at the beginning, we've helped clients both at the front end and if they end up into disputes. So that concludes the end of my introductory remarks about the region. And now please let me hand over to to Dan, who's going to talk about some specific issues relating to dispute resolution and arbitration in Vietnam.
Thanks, Mike. I thought we would start with just, again, a little bit of a drill down on some of those themes and how they're playing out in Vietnam at the moment. We're in the throes of COVID-19 still, but Vietnam really shines out, perhaps as an example of an exception in terms of how well they've done. From an investment perspective, Vietnam still saw GDP growth of about 2.91% last year. And I think from the records that we've seen, there's been in excess of $18 billion of foreign direct investment into Vietnam last year. So this is a jurisdiction of significant importance to international investors, particularly in the Asia region, and for today's purposes, particularly for Korean investors. So why are we talking about disputes then? Well, the reality is that as these large investments take place, set against the cultural and the political and the legal differences that Mike was talking about, we do see disputes arising on many of these projects and many of these investments. Each will have its own facts and its own circumstances, but I think there are a number of themes that come out from many of these, and I think we'll touch upon them. And I should say that's not just specific to Vietnam, but also to Indonesia, which is why both Gitta and I think will touch on some of these, and you'll see a common theme. When these disputes do arise, how do they get resolved? Well, our experience is that arbitration has become almost the default procedure for dispute resolution for Vietnam-related projects and investments. Extremely common to see arbitration clauses now in all sort of suites of commercial contracts, from sales contracts to EPC contracts and to M&A transactions. So what does the arbitration space look like within Vietnam? That's what I'm going to spend the next few minutes talking about. Well, like with many jurisdictions, there's a distinction between onshore arbitration and offshore arbitration. What do we mean by onshore arbitration? Well, that is where the seat of arbitration as chosen by the parties is within Vietnam. The main institute within Vietnam for onshore arbitration is the VIAC, the Vietnam International Arbitration Center. You may have, people on today's webinar may have had experience with VIAC or may have not, but it is definitely a growing caseload that they have. It's gone up significantly the last few years. I think in a large part due to its growing attraction for domestic matters, where the parties have decided that they don't want their disputes to be resolved by the local courts, but want to maintain and remain within the Vietnamese legal system. Now, for international clients, it's often usually not a preferred choice for reasons that we'll come on to. But I'm just going to spend the next couple of minutes just talking about the specifics of onshore arbitration within Vietnam. As I said, VIAC is not the only institute operating within Vietnam, but it's certainly the largest. They have a set of rules, they're publicly accessible, they're in a number of languages, they have a secretariat. So in that sense, you know, they'll be familiar to a user in the sense if you're using the ICC or the SIAC or the KCAB. But I think there are issues that we've seen come up in practice, particularly for disputes that are large, for cross-border, that are complex, that involve parties from different jurisdictions, highly technical issues, and where there is a significant value attached to them. Some of the problems that we've seen over the last few years perhaps arise from the way in which the rules are written and the way that they're applied. One of the problems that we've seen is perhaps in some, compared to other institutions, they can be quite institute-led, secretariat-led. So counsel operating and running an arbitration who might ordinarily under a different set of rules in an arbitration with a different institution, spend a lot of time cooperating with each other, coordinating with each other to agree procedures and policies and approach to the arbitration. We found that with VIAC arbitrations, a lot of that has been dictated by the secretariat itself and not by the parties, with documents going to the secretariat who then dispense those to the parties. It can be quite a slow and laborious process, perhaps rather than just getting on with things via email. You know, as Mike said just a few minutes ago, certainly the case here is it's quite a paper-based exercise. And in the current day and age where increasingly arbitrations are being run virtually, electronic filing and the like, that certainly presents a logistical challenge that many would prefer to avoid. There's then the more fundamental issue of being within the Vietnamese judicial system, in the sense that the Vietnamese courts will have supervisory jurisdiction over an onshore seated arbitration. Now, there are some perks to this. One of the fundamental distinctions in Vietnam between an onshore arbitration and an offshore arbitration is that for onshore arbitrations, once you have an award, you don't have to go through the process of seeking judicial recognition of that award. You can go straight to enforcement. That's not the case for international awards. However, there are some potentially significant downsides of being within that system. And I think those have played out particularly over the last few years by looking at some of the decisions that have come out on the enforcement of awards, even domestic awards. I think one of the examples that highlights this is a decision that came out, I think, in 2019 in relation to a project in which there were two Chinese investors operating. And in that case, the tribunal proceeded, issued award in favor of the international parties, albeit it was an onshore arbitration. But when the Vietnamese party tried to get that set aside, the Vietnamese court did set aside that decision. And it's the reasons why they're set aside that have set off some alarm bells. one of the reasons related to reliance by the tribunal on expert evidence on issues of quantum that have been put forward by one party. And the court seemed to take an approach of saying, well, the tribunal should have relied on their own independent assessment rather than preferring the evidence of one party over the other. There's also, we've seen confusion in some cases between the concept of the judicial seat, the arbitral seat, sorry, and where a hearing might take place. So again, in that case, it was an issue with the arbitrators deciding to have the hearing held in Singapore, even though the parties had agreed that the seat was within Vietnam. So there are these sort of trends and themes coming out from the Vietnamese courts that are not the most positive. There are some positive steps that we have seen, though. We saw last year the Vietnamese state starting to now issue statistics around the enforcement of arbitral awards, where in the past that had been quite opaque. And so in terms of getting transparency of what's going on in the jurisdiction, that's definitely a positive trend. So, you know, when you look at it as a whole, I think the preference for international clients probably remains for offshore arbitration. And there is a lot of room for improvement in terms of what is offered with onshore arbitration, but there are definitely positive signs. And hopefully that is a trend that we'll see continuing in the future. If we could just go to the next slide, please. So what are then the benefits to parties using offshore arbitration in Vietnam? I mean, I think we should start with recognizing that it is probably the preferred choice for high value, for complex transactions where there are parties coming from different jurisdictions, because ultimately what the parties want is they want neutrality, they want independence, and they want certainty. By removing yourself from that judicial system into a neutral forum, whether it's Singapore or Korea or Switzerland or London, UK, wherever it may be, that is a benefit that the parties are going to get. Similarly, working with an experienced, a highly experienced arbitration institute such as KCAB, SIAC, ICC, the parties are going to have the benefit of that experience in terms of the way the case is administered, the ease of administration, and the familiarity of the institute with the jurisdiction and the parties involved. There is this issue then on enforcement, as I said earlier. If you are in an offshore situation and you're trying to enforce an award within Vietnam, yes, Vietnam is a party to the New York Convention. Yes, it has the law on commercial arbitration that recognizes this, but it is this process that you still have to go to the Vietnamese courts, seek recognition, and then go for enforcement. And the reality of that, and we now see this from the statistics that have been published quite recently, is that less than 50% of cases are being successfully enforced. That is not a particularly positive statistic, depending on whether the cup is half full or half empty, but that is the reality of what the statistics show. When you drill down in that as to why perhaps awards aren't being enforced and the different reasons that courts have been relying on in doing so, one theme is often comes back to reliance on what is generally referred to as the public policy exception. That is that, you know, it offends the fundamental principles of Vietnamese law. And that's quite a broad concept. And one of the steps that the Vietnamese government has been looking to do is to try and tighten that. And there has been a draft resolution issued to try and narrow effectively the scope of that public policy exceptions, but I think it remains to still be seen how that's going to be applied and brought into force and be effective in the future. The final aspect, I think, of disputes in Vietnam is the relevance of politics. For many foreign investors, when they're coming into Vietnam, they will be interfacing with the Vietnamese government or state-linked entities, state-owned enterprises. And this is a common theme in many of the disputes that we work on, where we're helping clients navigate these issues with SOEs or with the government. And time again, we see a common theme playing out, which is the parties have a genuine commercial dispute and they wish to resolve that commercial dispute. They go to arbitration and they play out their claims and their counterclaims in the context of that procedure, and they get to a point where they want to settle that arbitration for whatever reason. And the issue arises that, you know, one party is claiming $100 million against the other party claims $100 million back. And if they then want to reach a settlement where they're essentially walking away from what they put on paper, there is this perception, there is this risk that the individuals involved in signing off on a settlement like that are going to be exposed to investigation by the state or other sanctions for essentially causing what is perceived to be a loss to the state. And there can be personal liability to attaching to that. So that can be a fundamental barrier to achieving what would otherwise be a mutually beneficial settlement for both parties. And this is something that we see time and time again. So that is a challenge, but how do we work around it? Well, you can see on the slide here, we suggested maybe having a condition precedent that consent has been obtained from a relevant regulator or a state auditor. But I think perhaps a more interesting development, and this is something that actually Mike and I saw on a case, which is where the parties adopted for mediation, and they were able to actually then have a decision under the guise of a mediated settlement that was then essentially signed off, that the parties could each rely upon, on particularly the state-owned entity party could rely upon and point to as being a reasonable justification for a settlement. Now, there was peculiar circumstances of that case, but I think I suggest that, again, in the future, mediation might be a good way of helping navigate this issue. I think many of these issues will be common to other jurisdictions around the Southeast Asia region. And so you'll definitely start to see some of these themes playing out, not just within Vietnam. So at that point, I'm going to hand over to Gitta now, who's going to talk about Indonesia. Thank you.
Thank you, Dan. I think I'm going to move on to the next slide now and discuss Indonesia with this group. You will notice that in the next 10 minutes or so, a lot of the discussion will sound very familiar because in some respect, many of the issues that Dan has flagged relating to Vietnam also arises and manifest themselves in Indonesia. I think starting first with arbitration, and I start there again like Vietnam, because for most foreign investors, including Korean parties, arbitrating an Indonesian related dispute is the default option because parties, especially foreign investors, are wary of going to the Indonesian courts for various reasons. Obviously, Mike touched on earlier, one of them is corruption and the susceptibility of the Indonesian courts sometimes to improper influence. Arbitration is seen as a more neutral forum in which their disputes can be resolved. Now, in the last few years, the recent trend that we have seen in Indonesia is that although the preference of the offshore or the foreign investors is to go for offshore arbitration, that is arbitration that is seated outside of Indonesia, typically Singapore is selected, but not always. These have increasingly become more difficult, especially in relation to projects involving state-owned enterprises, or projects where the Indonesian parties are dominant. And very often they will push, first of all, for Indonesian litigation or for Indonesian seated arbitration, what we call onshore arbitration. Now, obviously the preference is to go for offshore arbitration. However, if that's not possible, what we've worked with clients is to try to push for onshore arbitration. That is having your seat, say, in Jakarta, Indonesia. And although that's not ideal because that means you're subjecting yourself to the supervisory jurisdiction of the Indonesian court and the curial law of Indonesia for your arbitration, it is nonetheless still better than litigating in an Indonesian court. How you can then also improve your position is by trying as far as you can to actually select an international arbitration institution to help administer your arbitration. Very often there's this confusion in Indonesia that because you're asked to select Indonesia as the seat, the assumption is that therefore you must choose a domestic Indonesian arbitration center to administer your arbitration. This one refers to what we call as BANI, that's the Badan Arbitrase Indonesia, Nasional Indonesia. So that's the Indonesian Arbitration Center. And is one of the most established centers in Indonesia, and certainly the oldest. But again, we still don't recommend selecting BANI to administer the arbitration for very few practical reasons. First of all, The rules are not updated yet, so very often it cannot deal with complex dispute or issues and are not as detailed as some of the more established arbitration institutions out there. And secondly, and most importantly, the BANI cost of scale for arbitrators' remuneration is actually quite low, and that presents a very practical problem. Very often, distinguished arbitrators who are on their panel who have taken on a certain number of cases from BANI then refuse to take on more cases because the cost of scale is not remunerative enough. And that can be difficult when your dispute is, for example, a technical one, and you do need someone who's a technical expert or an industry expert to be part of the arbitration panel. BANI, unfortunately, operates a closed list, so you need to appoint someone from their list of arbitrators, or you need to apply to BANI to explain why you're departing from their list. And because of all these practical problems, sometimes it is quite difficult. It can be time-consuming to even get your arbitration started. So for this reason, we often recommend to our clients that when they are negotiating their arbitration contract, and they reach a point where they're forced or to agree to onshore arbitration, to push harder to select international institution to help administer the arbitration. Because unlike Vietnam, there's no confusion in Indonesia where the selection of a foreign institution will cause confusion as to what the seat is. There are many arbitration that are administered by international institutions like ICC or SIAC, or even ad hoc arbitration under the UNCITRAL rules, where the seat is in Indonesia. And that helps in ensuring that you get to select the arbitrator you want and to ensure that the rules used will be fit for purpose. So that's an important point to note, especially with the increase of state-owned enterprises insisting that arbitration should be onshore. The other point that we've seen with the selection of Indonesian seat is that some of the investors are caught unaware of the peculiarities in the Indonesian curial law. So law number 30 of 1999 is the law that governs arbitration seated in Indonesia, as well as enforcement and recognition of awards from offshore arbitrations. If you have selected Indonesia as the seat, there are certain rules in there that you need to be mindful of, and then you may need to consider whether or not to waive. So for example, one of the provisions found in law number 30 that applies to onshore arbitration is the power given to the tribunal to decide on issues in dispute based on principles of law or based on principles of fairness and justice, what we know in other jurisdictions as the ex equo et bono principle. If you do not want the arbitrator to apply principles of fairness and justice to depart from what would otherwise be the conclusion or determination based on principles of law, you need to have that expressly excluded. We've had clients who come to us after the dispute has been decided, asking whether they could try to set aside the award because the tribunal decided that even though Indonesian law says X, we don't feel that's fair, so we're going to decide Y. And because that principle of fairness and justice have not been excluded, it's difficult to ground any objection to the award on the basis of it was unexpected or unfair. So that's some of the peculiarities you need to take note of. The other one that's also confusing is the recovery of costs. The position is unclear in Indonesia because there is a school of thought that says that Indonesian public policy precludes the recovery of legal costs in Indonesian seated arbitration. It hasn't been finally determined yet, and the issue is an open one. So there's a risk that if you try to recover costs in an Indonesian seated arbitration, the unsuccessful party may then try to challenge it. So what we find is that there are parties who strategize by ensuring that the tribunal issues any award on costs in an onshore arbitration in a separate award, so you do not infect the rest of the award in case the award on costs gets challenged. So that's it on some of the tips on onshore arbitration. The other final point I would make before moving on to offshore arbitration is that if you are pressed to use BANI, that's the Indonesian Arbitration Center, as the institute to administer the arbitration, you should ensure that you select the right BANI. What do I mean by this? A few years ago, there was a dispute between the founders of the original BANI, which then resulted in some of the unhappy founders to leave and set up a new institution. Unfortunately, rather than picking a new name, they've decided to call it something else, which is BANI Renewed. That's not helpful because then you have two different banis, and right now there is uncertainty in Indonesia as to whether or not the second bani is actually legally empowered to administer arbitrations in Indonesia. To avoid any confusion, you need to specify that any reference to bani would be to the original bani, and that's a point of drafting to include in your arbitration agreement. To the extent you cannot avoid it, and to the extent you cannot choose an international institution, such as KCAB, for example, to help administer an Indonesian seated arbitration. I now move on to the second topic, which is on offshore arbitration. So obviously, if you pick offshore seat, it will become an international award. And it also means that the seat selected will have its court being the court with supervisory jurisdiction. Arbitration-friendly jurisdictions such as Singapore will allow parties to, for example, avail themselves to interim relief from courts and not just from arbitral tribunal. That's not something that's available because Indonesian curial law on arbitration does not permit seeking interim relief from a court in aid of arbitration. In terms of how you get your award recognized, Indonesia is a party to the New York Convention. So in theory, it can only refuse recognition on very, very limited grounds. So what we find as a matter of experience, and there are some statistics to back this up, is that the first step towards getting your award enforced is the easiest and most straightforward step. That's the registration and recognition step. And we find that there's a statistic that says that almost 95%, if not more, of foreign awards that get registered in the Central Jakarta District Court, that's the court authorized for all registration of offshore awards, gets registered within 6 months, but the fight really starts after the registration process and the actual enforcement process, where you then try to enforce it against assets of the judgment debtor. That's where it gets very difficult again in Indonesia, because you then take yourselves out of the jurisdiction of the Central Jakarta District Court, which is one of the better courts, and then you are at the mercy of the court which has jurisdiction over the assets or the judgment debtor. So we've had experience of having to help clients enforce award in against the assets of the judgment debtor somewhere in the middle of Sulawesi and Borneo, where the courts are not sophisticated, and it can be quite difficult and time consuming. So when you plan for an arbitration in Indonesia, always have in mind the enforcement process, because that in itself can take a few years on a worst case scenario. In terms of other trends and issues specific to Indonesia, as many of you who do business in Indonesia will be aware of the controversies around the language law. So the language law requires contract entered into with an Indonesian party to be in Indonesian as well as in English. One little quirk of the language law that sometimes get missed, and we've got real life examples of helping clients who are stuck in that situation, is that where the contract is between two Indonesian parties, the prevailing language has to be Indonesian language. That means the version that gets executed has to be at least in Indonesian language. So what that means is that if you're a foreign investor, but you have incorporated a company in Indonesia, then you are treated as an Indonesian party. So you do need to then comply with that requirement if you're entering into a contract with another Indonesian party. The final point that I want to make is the same point that I think Dan has mentioned, in that if you deal with state-owned enterprises, it can get quite difficult if, let's say, a dispute arises and you try to settle it amicably, because under Indonesian law, there's this concept of causing loss to the state, what we call the state loss law. And it's drafted so widely that it's actually been weaponized or politicized and used sometimes against companies and directors who made genuine business decisions to settle a dispute or to enter into a business that may not turn out well in the end. But instead of saying that was just a business decision or a calculated decision based on commercial reasons, the law has been used against such decisions to say that they've caused loss to the state, and therefore the director in question becomes criminally liable. So the most recent example of that is to do with the Pertamina CEO. So in 2019, she was actually found guilty of causing loss to the state and was sent to jail for 8 years due to a business decision made by the company to invest in an Australian oil and gas field. Even though it was a genuine business decision, they say that it was a bad decision and she's caused loss to the state and therefore criminally liable. Thankfully, the Supreme Court reversed that decision and found that you cannot use the law in that way. But she spent a year in jail before getting to the right outcome, and this explains why many state-owned enterprises in Indonesia and the directors will be very reluctant to enter into settlement agreements and would rather spend the money to get an award or a judgment because they're terrified of being falsely accused of causing loss to the state. Does this mean that you can never enter into a settlement agreement? Not necessarily. If you are the counterparty, there are ways to try to get your SOE party to agree to a sensible settlement, because they can actually get things like an opinion from the Attorney General or from the state auditor to look at the rationale and the commercial logic behind a proposed settlement and confirm that it will be compliant with the law, or at least is made in good faith and not with any intent to cause loss to the state. So that can actually be made, for example, into a condition precedent to any settlement agreement. So there are ways to try to get your settlement across the line, but this is just something to be mindful of and explain why you can see a lot of reluctance on the part of many state-owned enterprises to engage in any form of settlement negotiations. So with that, I will hand you back to Dan, who will kick off the discussion on third-party funding in Singapore.
Thanks, Gitta. Closer to home for us sitting here in Singapore, third-party funding has been probably one of the biggest game changers in the dispute resolution landscape here in Singapore, and then by extension, the broader Asia region. The reason for that, I think we've touched on this various times over the last almost hour, is Singapore's role as a dispute resolution hub. It is increasingly becoming the default choice for international investors investing around not just the ASEAN Southeast Asia region, but the broader Asia Pacific region and even beyond. So what do we mean by third-party funding? And what is the system here in Singapore? Well, this is the process by which parties to, in this case, an arbitration, can have the legal fees and other costs associated with pursuing an arbitration against a counterparty paid by an independent third party. Historically, this has been not permitted in Singapore, as in many jurisdictions, because of the perceived difficulties of independence with the arbitral procedure. Now, Singapore fundamentally changed their framework in 2017 to allow third-party funding in international arbitration and associated proceedings. And now it covers domestic arbitration and associated mediation proceedings as well. One of the requirements of the framework is that if you are a party commencing an arbitration, pursuing an arbitration, and you are being funded by an independent third party, that now has to be disclosed. With it comes some interesting strategies and consequences of that I think Gitta will touch on in a moment. But the landscape has developed quite a lot just over the last 3.5, almost 4 years now. We've seen the new regime bringing in big international funders. We had IMF, who did the merger with Omni Bridgeway. They've grown significantly in the jurisdiction, as well as Burford Capital, Woodsford litigation as well. And with each of these funders who are establishing themselves in the market and are beginning to fund more and more cases, we're seeing a growth in caseload. I don't think it's the single overriding factor why there's been a growth in caseload, but it's certainly a factor that is driving an increase in cases. In terms of our own practice, we've seen this where we are representing parties, certainly in the cases that I have in mind, defending claims bought by funded parties that would never have been bought, would never have been commenced if those parties would not have had access to independent third-party funding because of the often high and heavy costs associated with pursuing arbitration proceedings for large, complex matters. I mean, that has to be balanced against the access to justice point. And this balance between access to justice and the perceived risks of an increase in dispute resolution, there seems to be striking a good balance in Singapore. The feedback that has been given through the public consultation processes run by the government over the last couple of years has been overwhelmingly positive. And I think there are, from our understanding at least, is that there are plans afoot to potentially liberalise the funding market even further in Singapore. So the the uptake of that is, I think the funders are optimistic about enforcement prospects as well around the region. They're funding more cases. They look at obviously each case on the merits, in particular with enforcement in mind. Unlikely they're going to fund a case where they know they're going to have significant difficulties at ever recovering. But our sense is that while each funder has a different risk appetite and a risk profile, they are definitely keen to be funding cases in this market, and that again is driving this increase in caseload. Another consequence of that is moving to the transactional space where people are negotiating contracts. This is yet another factor that parties are taking into consideration when deciding to put in arbitration clauses in their commercial contracts and agreements to have their disputes funded in Singapore, because they know if that ever happens, one option would be to have access to funding, whether because they've got a financial crunch, a lack of funds, or just as a commercial body that wants to take that risk off its balance sheet and use commercial funding as a sensible risk management tool. So overall, I think the message is positive from the public funding, the third-party funding regime here in Singapore. I'm now going to hand over to Gitta just to talk about some of the specifics that we've seen in the strategies and how that's playing out in cases in real time.
Thank you, Dan. So I think this is our last substantive slide for this session. I mean, starting from the perspective of you're a party seeking funding, you typically will do that at the very outset of a dispute, and you want to start engaging your lawyers or lawyers who are familiar with how to go about it with the funding process and what the kind of questions that the funders will ask. So we've been lucky in that we've done a couple of these now, and what we know from the funders, as Dan mentioned, is that they will always have enforcement in mind, right? Because their whole business is about getting a proportion of any award made in favor of the party seeking the funding. So it's very important that when you speak to funders, you've got to have enforcement in mind, and in a way that's not that different than running your own case. So there's no point running a full entire arbitration and getting a good award if enforcement has never been thought of, because then it's not worth the paper it's written on. You need to be able to know whether you can convert that award into money. And in order to answer that question, you will need to be looking at the kind of assets that are available that you could potentially enforce the award against, and in which jurisdictions. The question that we very often get from our clients is that if I have an issue or a dispute or a project in countries, emerging jurisdictions like the Philippines, like Indonesia, like Vietnam, what are the odds of a funder wanting to take that on, given all the difficulties associated with enforcement? And the answer is that actually it's not all hopeless. We've seen cases being picked up by funders, and they involve enforcement or parties in those jurisdictions. The key is to show the funder the different paths to enforcement. So Dan talked about your transaction early on. So for example, cases that stand a better chance of funding are cases where you can show the funder that it's possible to enforce outside of those jurisdictions, or even if you have to go into those jurisdictions, there are real tangible assets that are easily available, for example, by way of a share pledge, or if there is a guarantee by a parent company or a shareholder. So you need to conduct a fair analysis of the merits of the case, because otherwise that could prolong the process. There's no point trying to hide the weak points of the case. It's better to be upfront about it, because the funders themselves will be very sophisticated. They'll have their own in-house legal team analyzing your case. So it could take months if you do a back and forth rather than having a complete analysis of the case and presenting that to the funder. So that's when you seek funding. What happens if you are then sued by a party who's been funded? Again, like Dan mentioned, we've had successes in that area too. So there are strategies that you can employ to ensure that you stand the best possible chance of not losing the case if the merits are such, or better still, to even use the fact of the existence of a funder to your advantage. In one of our most recent cases, we've managed to get a course award against a funded party on a full indemnity basis, on the basis that from the outset, we took protective steps for our client by putting in sensible settlement offers that were eventually rejected, and ensuring that the arbitration was conducted in a reasonable way to build a case when you reach the cost submission stage, to say to the tribunal that this is a funded party who obviously did many of the applications without regard to cost because they are funded, but in fact, they are actually unreasonable or unnecessary, and the tribunal was persuaded and actually awarded costs on an indemnity basis. So all is not lost if you're being sued by a funded party. It's just making sure that you can use that to your advantage and you protect yourselves through conducting the case sensibly. So I think with that, we've come to the end of our presentation. I'll hand you back to Mike, who might lead on the Q&A session.
Thank you very much. Thank you very much, Gitta and Dan. It was a very helpful and informative presentation. Please, everyone in the audience, please do submit your questions. We would all, particularly Dan and Gitta, be very interested to hear them. We've had one question so far from the audience, so let me read it, and Dan or Gitta, maybe you could help us with an answer to it. I think it's one for you, Gitta.
Yeah.
It's a question in relation to the Indonesian language law. And the question is, the person wonders whether the prevailing language should be the Indonesian version in case of a contract between an Indonesian company and a non-Indonesian company.
Oh, the answer to that is that you don't have to. If there is a foreign party involved in the contract, you are allowed to select the non-Indonesian language as the prevailing language. And in that situation, all you need to make sure of is that there is an Indonesian language there. And then typically parties will have a clause to the effect that if there is any inconsistency, the foreign language version will prevail.
Thank you, Gitta. And another question I have that I imagine would be very relevant to those in the audience, and it's a question to both of you in the context of Vietnam for Dan and Indonesia for Gitta. But what are some of the things in relation to either dispute resolution clauses or structure of contracts more generally that you think Korean parties could do to put themselves in the best possible position when when they are entering into a contract in those two jurisdictions? So not necessarily when the arbitration has started, but at the front end when they're drafting the contract, what are the things you would recommend that the in-house counsel and the lawyers on this call who are advising parties going into Vietnam and Indonesia to think about when they're putting those contracts together? Would you like to start, Dan, maybe with about Vietnam, and then Gitta, maybe you could consider the same question related to Indonesia?
Sure. I mean, some of these are perhaps relatively straightforward propositions, but I think touching on the themes I covered earlier, there's a strong preference, and I would strongly recommend the choice of an offshore seat when you're investing into Vietnam. I think having that additional neutrality and certainty right up front, and having been considered right at the outset, is going to stand you in pretty good stead. I think the second element to it is, and this is often overlooked most egregiously, particularly in the construction space, when you're dealing with public projects and you're dealing with counterparties who are essentially emanations of the state, there are issues around sovereign immunity that often just get either forgotten about or just don't get taken into account during the negotiations, particularly in the construction sector, where people are bidding on standard form documents often, or against a standard form document with a particular set of conditions attached to it. And the problem there is that, that's all very well and good at the outset of the project, but when you come to enforcement, and particularly trying to enforce outside of Vietnam, and you haven't got a sovereign immunity waiver, that's going to present, or can present, a pretty significant hurdle to recovery. So, that would obviously be an outcome anyone investing into Vietnam or anywhere really, you would want to avoid. And I'm sure, Gitta, that applies equally to Indonesia, right?
Right, Dan. And I think at a more general level, if you're in Indonesia, I see this very often where the governing law clause and the dispute resolution clause are treated as a package. And very often, clients panic when, let's say, the governing law clause get changed from, say, English law or New York law or Singapore law to Indonesian law, and they think that, oh no, that's the end of the world. But it can be used to your advantage, because if if you pick a good dispute resolution forum, having Indonesian law govern your contract is actually not the end of the world. The problem in Indonesia doesn't stem from the Indonesian law existence. It stems from the way it's been applied and interpreted in the Indonesian courts. But you take all those problems out of the equation if you have Indonesian law, but you choose an offshore arbitration and an offshore arbitral institution who will then ensure you will select very sensible, good people to adjudicate your dispute. The Indonesian law is based on the civil law system. So, it works in the Netherlands, it works in France. It should, in theory, work in Indonesia if applied and interpreted sensibly. So you can almost use that to your advantage by saying to your counterparty, fine, I will accept your selection of Indonesian law, but please accept my option of using Singapore as a seat or using, say, an international arbitration institution to administer the arbitration. And you might end up actually with a better result because it looks like you're compromising, but you're actually protecting your contract and your ability to recover in the event of a dispute. The other point about that's quite useful is that, again, because governing law and dispute resolution clauses are often treated as midnight clauses, it tends to be looked at the end, and then people go, oh, fine, we'll change it from English law to Indonesian law at the last minute without thinking through the consequence of changing from one system, which is a common law system, to a civil law system. And there may be additional clauses that you then need to build in to protect yourself. And one clause that sticks out vividly to mind is the fact that in Indonesian law, if you do not waive a particular provision in the civil code for termination, it means that you cannot terminate a contract without a court order. So that needs to get waived if you select Indonesian law and you want to be able to terminate by notice, for example, or for convenience, for example. Otherwise, you need to arbitrate or litigate in order to be able to terminate. So I think that those are the 2 points from me, Mike.
Great, thank you. I think we're running out of time because I see Mr. Lee popping up on the screen. Mr. Lee, I had one more question, if you would permit me. I think might be relevant to the audience, and maybe Dan and Gitta, you could answer this quickly. But just putting the shoe on the other foot, we're in a Korean KCAB arbitration, but we need to take that award, the successful award for our Korean clients. We need to take that and enforce it in Vietnam or enforce it in Indonesia. What would any tips for what we can do to make sure that we have the best possible chance to enforce that award in Vietnam and Indonesia? Quickly.
Shall I do it first? So if it's an offshore award, Mike, what you need to remember is that in Indonesia, the arbitration law of Indonesia actually says that the job to register the award falls on the tribunal. So you want to make sure that before the tribunal becomes functus, that means over and no longer in power, that it issues a power of attorney authorizing the parties to carry out the registration and enforcement on its behalf. So a lot of the institutions are very, very aware of this. So they make sure that the tribunal doesn't forget that, and that it's part of the checklist that the power of attorney is granted with or just before the award gets issued. But if you're in an ad hoc situation, you just need to make sure that your lawyers are aware of this and you remind the tribunal of this as well. So that's a tip. And then the other thing is that you need to have a proof that the institution is a valid institution in that country. So sometimes, that can get quite confusing. So if you have a standard operating procedure for the institution, it helps to then issue that to the parties so that they know what to do. It typically involves bringing a letter from the institution and getting it consularized at the Indonesian embassy. And then if you have all those documents in place, registration should be quite quick.
Actually, the enforcement issues are always very critical to arbitral institution as well. So after the issuing final award, we got many questions from the clients or parties as well. But anyway, the Gitta's response could be, I think, very satisfactory, and then there is nothing more I could add because I'm not the knowledge about this, to be honest. But actually, I have one personal question to Daniel. So, as a person working in arbitral institutions, so it would be appreciated if you give your opinion. So as far as I understand, despite some uncertainties, so Vietnam is making notable efforts to improve accessibility to arbitration, right, these days. And combined with the fact that Korean companies, and no matter how much size or scale it is, they have become very active in Vietnam, right? So in order to give legal advice to them, almost all Korean big law firms have also founded their Vietnam office or branch there. And that is also why, in order to match the kind of like such growing demand, the KCAB established our third overseas office in Hanoi as the first and only foreign arbitral institution in Vietnam. So I'm wondering, my question is, in the perspective of arbitral institution, whether this kind of positive atmosphere will continue for long without certain potential risk, and what should be the kind of next step or strategy to achieve institutions ultimate goal to expand our influence over there?
A weighty question. A lot
Okay.
of future gazing there, but I think it's a multifaceted problem. It's about ensuring effective case management. It's about having, like the KCAB does, effective rules that are modern rules. I'll just pause there briefly as in just to come back to the problem before we talk about the future. One thing I've seen in domestic Vietnamese arbitrations, particularly where even when you've got a mixed tribunal, partially Vietnamese, partially international, is a reluctance to go beyond what is expressly stated in the rules. So one of the big benefits of arbitration is we always talk about procedural flexibility. But if you find yourself in an environment that the people who are effectively running arbitrations are saying, well, it doesn't say that you should do that in the rules, therefore you can't do it, as opposed to it is not prohibited by the rules, so we'll decide just based on the particular facts and circumstances of the case, is it an effective case management tool to do it? That mentality also, I think, needs to shift. And I think that comes through collaboration between the institutions, with government, with the Ministry of Justice, with end users, with counsel. And I think a really positive step has been the steps that are being taken by the Chartered Institute of Arbitrators and others to help educate lawyers and end users about what international arbitration is, what international best practice is, so that people don't look at things like the IBA guidelines as usurping domestic law, as happened, I think, in the case that I referred to earlier, and people use it, look at it as simply a guide and as best practice in a way that we can improve the process which is ultimately for the benefit of the end user.
Thanks. I think we have already passed the expected end time for webinar, and it's time to wrap up. So is there any more comments you guys want to add? Before?
Mr. Lee, there's one more question, late question just in from the group, so maybe Gitta could help us answer it.
Okay.
Gitta, the question is, would third-party funding be considered an enforcement barrier in Indonesia?
The answer is no. In Singapore, it used to be a problem because of the Champati rule, and that rule actually never exists in Indonesia. So technically, there are lawyers out there, for example, in Indonesia, who offers contingency fees, although that's not advisable because some of the risk associated with the perception of what that contingent is. But because of that, there's an absence of rules or barrier or prohibition against having funding or having some sort of funding arrangement. As a result, we do see a lot of funders being interested in fact, funding cases involving Indonesia with seat in Singapore.
Okay, and all of a sudden there's something pop up in my brain. So I have one more question. Okay, so in contrast with Singapore, maybe Hong Kong, Korea is still not that optimistic toward third-party funding. Actually, or rather, I think, in my opinion, still so skeptical, since it is basically not permitted under the law. I guess, despite more gray area to be analyzed. But however, as you know, there are no clear ways to stop Korean parties or recognize them whether they are utilizing the service, especially such as offshore arbitration, I guess. So could you share your general idea or experience regarding Korean parties in terms of third-party funding, or if not, any prediction is fine as well.
I mean, Mike, perhaps that's one that you might have some thoughts on in terms of the Korean clients that you've seen in the interest and appetite.
Well, there's definitely interest. There's definitely interest and for it, and you know, I know a lot of Korean clients have taken advantage of it. You know, there is a grey area in Korea, like there are in many civil law jurisdictions, but that grey area plays to your advantage because there is not an express prohibition on it the way there is in common law jurisdictions with the doctrine of champerty. So if clients are prepared to be bullish, you know, there's not the same risks as if you're doing it in a common law jurisdiction where there is an express prohibition until such time as they enter legislation to get around that. And that becomes even more so the case for international arbitration. So you know, Korean clients involved in international disputes away from Korea. I've had a number of discussions with clients around funding. I think what sometimes holds it back is more sometimes the commercial terms. You know, the funders take large profits from successful awards, and if you're doing a very sort of blunt financial analysis of, you know, what's the worst case exposure, or sorry, what's the worst case payment that we would have to make, it's usually quite large, and I've seen that put off a lot of clients. But I think, as with many jurisdictions, the interest towards funding is only increasing. I guess the other thing I would add is that the funders, particularly in the pre-COVID times, were regular visitors to Korea. So you know, they see this as a market to invest in. I think something I would say to the clients on the line, and indeed the you know, potential Korean co-counsel firms who are listening, there haven't been many Korean clients, as far as I'm aware, that have done sort of funding arrangements. And most of the funders are very keen to get their foot in the door. So that I would imagine there would be quite advantageous funding terms, you know, for the brave few who are prepared to go first.
Thank you, Mike. Okay, then due to time restriction, okay, I think it's time to wrap up. So thank you all for this very informative presentation, and it was very interesting to hear all of your candid views. And this webinar will be uploaded later this week on KCAB International's YouTube channel. So if you have missed earlier parts of the webinar by any chance, please check on our channel later. I would conclude by thanking all the speakers and attendees for joining today, and hope everyone stays safe until the next time of our webinar, and enjoy the rest of the day. Thank you. Bye. See you again.
Thank you very much. Bye.
Thank you, everyone.
Bye.
Bye.